Welcome, attendees and panelists. My name is John Tsuda, and I'm a distinguished fellow with the Boyd School of Law at the University of Nevada, Las Vegas. Thank you for joining us today for our panel on proposed DOI regulations on tribal state gaming compacts. This panel is presented by the Indian Nations Gaming and Governance Program at the Boyd School. The approval of gaming compacts between tribes and states has become a high-stakes endeavor, with both sides seeking the best outcome for their governments, while at the same time recognizing that the operation of gaming enterprises can be beneficial to both. IGRA requires that the Secretary approve these compacts, but it is a discretionary act by the Secretary. There are some tight timelines, some strict boundaries in IGRA that apply to this decision, and sometimes those decisions need further interpretation. The Secretary has proposed amendments to the original 2008 regulations to try to achieve a better job of providing an interpretation of both the Act and how the Secretary applies the Act to his or her decision to approve a compact. We are now awaiting, the draft regulations were issued in December of 2022, and we are now awaiting the final rule to be issued after a substantial number of comments have been submitted upon the proposed rule. This is a great area of the law, a great area to study. We have two professors who are visiting faculty with the Boyd School of Law with us to share their insights. These two professors are the preeminent scholars on Indian gaming, and I've been studying this for a long time, and I'm happy to say that I've known them for a long time and appreciate the work that they've done in this area of the law. And so without further ado, let me introduce them. With us, we have Professor Catherine Rand. As I said, she's a visiting professor at the Boyd School of Law. She's a senior distinguished fellow in tribal gaming at the International Center for Gaming Regulation and is the co-founder of the Institute for the Study of Tribal Gaming Law and Policy at the University of North Dakota. With her is Professor Stephen Light, who is also a visiting professor at the Indian Nations Gaming and Governance Program at the Williams Boyd School of Law. Mr. Light is a senior distinguished fellow in tribal gaming at the International Center for Gaming Regulation and is also the co-founder of the Institute for the Study of Tribal Gaming Law and Policy at the University of North Dakota. I will serve as the moderator and provide some additional questions to spur our discussion towards the end. I think that I will primarily, though, try to stay out of the way and let Catherine and Stephen enlighten us. There will be a chance for everyone who is participating today to ask questions, give our panelists a chance to respond at the end of their presentations. For those of you in the audience that wish to ask questions, you will be able to ask them in the chat room. Those will go into a queue and will then be presented to me so we can have our panelists discuss them. With the procedural stuff taken care of, let's proceed with our discussion. Professors, why don't you go ahead?
Great. We're happy to do it, and we're happy to say hello and a big greetings to everyone who is with us today virtually and online. And our thanks also to John for that generous introduction. We should note to you a couple of things as we get started. Number one, Catherine and I are obviously in the same room here in our office, coming to you live. We're coming to you actually from Minnesota right now. And luckily, the light is pretty good, but we do want to note that being in rural Minnesota, we actually had a power outage not long before this was scheduled to start. And with some great problem solving from the team, here we are. We think that everything will go great. And we've got Steve Isaacs driving the slides for us. But if for any reason, the Wi-Fi gets wonky or whatever, we'll join immediately as quickly as we can. So the digital divide in action, but here we are.
So we thought we'd start out for today's discussion of the proposed federal regulations on the Secretary's review of tribal state gaming compacts with the question about why are new regulations needed. So we wanted to talk a little bit about the compact requirement, how the Secretary reviews compacts, and some legal developments, most notably the Supreme Court's decision in the Seminole Tribe case that have led to some recurring issues in compact negotiations, which the proposed federal regulations are meant to address. So that's what we thought we would start today's discussion with.
So in that regard, we know that we have, of course, probably a wide range of knowledge and background and expertise in our virtual audience today. And so we're going to try and hit the sweet spot as best as we can in being informative, in catching some folks up, in bringing other folks along, and then in pushing the discussion forward along with John's help and, of course, any questions that might come from you all out there. So that's our goal. We're thrilled to be here today. We also just want to take a moment to thank the great staff there at the William S. Boyd School of Law and in the Indian Nations Gaming and Governance Program specifically. On the line, we know, for example, we have with us Danielle Finn and also Stephen Isaacs of the Indian Nation Gaming and Governance Program. And our thanks to everyone who is affiliated with Boyd School of Law for this opportunity. So as we get started then.
So we are used to pressing next slide, but since we we'll ask Stephen to go ahead and just move us to the next slide.
Yep.
And so where we want to start today is IGRA's compact requirements. So the Indian Gaming Regulatory Act requires the tribal state compact for Class 3 gaming. Let's move to the next slide and take just a quick look at that requirement.
So in taking a look at this initially, there's just some foundational knowledge. Again, we know some of you may have this. It's always good to have a refresher on some of this background. So where we start is thinking about the federal regulatory framework for Indian gaming generally. And that starts, of course, with the Indian Gaming Regulatory Act of 1988. Among the keys for us today in that background are thinking about the statutory requirements that apply for, broadly speaking, for Class 2 and most significantly for us today, Class 3 gaming. That gives us a framework not just for gaming, but for public policy and governance as well. Fits very well with the mission of the Indian Nations Gaming and Governance Program, as well as the imperatives for many indigenous nations across the United States. The key requirements for us include some definitions and thresholds that need to be met. First of all, the requirement in IGRA that gaming is to be conducted by an Indian tribe. That's a term of art, so we'll be using some terms of art today. So conducted by an Indian tribe, that is a federally acknowledged tribe. Secondly, the requirement and the definition of Indian lands, another term of art for us found in IGRA, another key threshold, so that the gaming that is conducted must be conducted on Indian lands, lands that are under the governance authority and jurisdiction of the particular tribe or indigenous nation. That's key in thinking eventually about these proposed rules as well. A third requirement for us is that the gaming that we're talking about, the tribal gaming, must take place in a state that permits such gaming. This is the so-called scope of gaming requirement that's found in IGRA. And it tells us something about the nature of the law and public policy that needs to be in place in a particular state in order as a threshold matter for a tribe to be able to offer. In this case, we'll be thinking primarily about Class 3 or casino-style gaming. And I should say we'll be alternating some, so Catherine, you can jump in at any point. Our fourth requirement for us is thinking about some of the necessary steps that IGRA requires as well in order for such gaming to be offered by a tribe. So the gaming in question must be in accordance with a duly passed and approved tribal gaming ordinance. In other words, the tribal government that is offering this needs to have authorized that particular gaming operation. It also needs to be in accordance with the broad federal framework found in IGRA, presumably all of the rules that are promulgated in accordance with IGRA as well. Any federal regulations that might be promulgated, for example, by our primary federal regulatory authority, as well as tribal authorities and state authorities as applicable, but here at the federal level, the National Indian Gaming Commission. So for Class 2 gaming, which is bingo and games broadly construed like bingo, non-house bank games, the requirement would be also that such gaming is offered pursuant to all tribal and federal regulations. In other words, the general idea that is specific for tribal gaming and tribal gaming alone, not for the commercial sector, that there are these classifications of gaming and the specification of authority and jurisdiction over that gaming. So here, Class 2, two areas of authority, tribal and federal. Ooh, the light has come on, so which is good news for us. So we're going to let Steve continue to drive, but that means for the moment we have power. Yippee. And oh, there we go. And for we're still on. Okay, just double checking. So for Class 3 gaming, we're thinking about gaming that is offered in accordance with one fundamental other requirement, the additional requirement of a duly negotiated and approved tribal state compact that sets forth the jurisdiction and various requirements that the tribal gaming will comport with. And so for Class 3 gaming, we're thinking about 3 levels of regulation then. The state has some authority pursuant to the compact and the federal government as well. So those are the basics for us in our IGRA framework. We're assuming, by the way, we're good to go. John, you can see us and hear us. Just want to double check.
Yep, I can still see you. You get a little fuzzy volume every so often, but so far doing pretty good.
Okay, good. Fantastic. So Steve, I think you can go to the next slide for us, please. So against that backdrop then of thinking about IGRA and its regulatory requirements, we have what Catherine and I have called the Casino Compromise, and others, of course, involved in the drafting of the legislation, the bill that became IGRA, have also spoken to this issue at the time the legislation was created. But the basic idea of the Casino Compromise is one in the aftermath of the Cabazon decision, California versus Cabazon ban of mission in Indians in 1987, which opened the door to tribes to offer these kinds of games and opened the door to thinking about the extent of state authority, if there is state authority at all. In the aftermath of that, the Casino Compromise was one that balanced or rebalanced after the Cabazon decision, both state and tribal authority, while introducing that federal authority as well. And so in delegating federal authority to the states, Congress took action through the IGRA framework to rebalance that authority, to encourage cooperative policymaking, to encourage government-to-government relations, as a recognition of tribal sovereignty as well as state sovereignty, and to ensure that tribes have the opportunity to offer gaming that would advance their public policy goals and be primarily for the benefit of their own members, their own citizens. What it did, though, as in thinking about that compromise, the dual meaning, if you will, of compromise is that it compromised some of tribal sovereignty and tribal authority. It allowed for the states to have a role. It delegated that role expressly to states. And in requiring states to negotiate compacts, or tribes to negotiate compacts with states, I should say, it did also put in place a framework that we'll be talking about some in relation to these proposed regulations, requiring states to negotiate in good faith, as IGRA required, and creating an enforcement duty and enforcement opportunity in federal court of the state's good faith duty to negotiate. What IGRA also did was delegate a role to the Interior Secretary, the Federal Interior Secretary as well, in having review authority over the compact that's been negotiated. And that's going to be important for us in thinking about what these rules are trying to clarify and do many years later.
So importantly, Steve, I think it's fair to say that while Congress thought it was appropriate for the states to have a role in Class 3 gaming through the Tribal State Compact requirement, Congress was very careful about that and imposed a good faith duty on the state that under IGRA was enforceable in federal court, and also required federal oversight of any negotiated compact through the Secretary's review of a completed compact.
Yes. Steve, you can go to the next slide for us, please. So let's talk a little bit about IGRA's good faith duty to negotiate, because that, again, is going to be relevant for us down the road a little bit here. So among the requirements as part of that good faith duty, IGRA obligates states to negotiate in good faith, as we just said, toward a Class 3 compact and thinking about the scope of gaming that the tribe can offer. IGRA also creates an enforcement mechanism. The enforcement mechanism, as it was created through IGRA, was the authorization of a tribe to sue a state in federal court if the state failed to negotiate in good faith. And so it creates that review requirement and that enforcement mechanism, effectively giving teeth to that good faith requirement. In terms of the specifics there, a tribe's lawsuit, a cause of action triggered by failure to reach a compact, would be triggered within 180 days. There's various procedures and remedies that are detailed in the statute on a finding of a lack of good faith. But really importantly, and Catherine could speak to this as well for a moment, what IGRA does is create very specific mechanisms, remedies for states' failure to negotiate. What are those mechanisms, Catherine, and what's the significance of them for us?
So if a tribe believes that a state has failed to negotiate in good faith, it must present some evidence to support that. Then the federal court has the opportunity to find whether or not the state failed to negotiate in good faith. If the federal court finds that the state failed to negotiate in good faith, only certain things happen. The first thing that happens is that the court sends the state and the tribe back to the negotiation table with that finding in mind. If they still can't reach a compact, then the federal court can appoint a mediator to help them work through whatever issues and reach a compact. If that doesn't work, then the last ditch effort under that federal cause of action is that the Secretary of Interior can actually issue administrative procedures in the terminology of IGRA, what we might call essentially an administrative compact to allow the tribe to operate Class 3 gaming. Congress's idea then was when we were in a state that permitted Class 3 gaming, the tribe ought to be able to operate Class 3 gaming as well. The state has a chance to determine how that Class 3 gaming will be operated and regulated through the compact requirement. But if the state can't reach a compact in good faith, then ultimately the tribe would still be able to operate Class 3 gaming under these administrative procedures.
So we'll hold all that in mind. Again, if folks have questions along the way, feel free to drop them in the chat for John to take a look at. But let's go ahead, Steve, and move forward here and continue to paint the portrait of the background we need to understand why these rules or proposed rules. So the next step along the way is to think about the U.S. Secretary of the Interior's review of the compact. So once the compact is negotiated, presumptively negotiated, then the tribe is compelled under IGRA to submit the compact to the Secretary for administrative review. Now, the Secretary has some options here, and these are significant for us as well. In essence, what the secretary can do is approve of the compact, disapprove of the compact, or do nothing, and we'll flesh out what that means a little bit. What are the implications of that, Catherine?
Sure. So the secretary may disapprove a compact for only 3 reasons: that it violates IGRA, that it violates other federal law, or that it violates the federal government's trust responsibility to the tribe. That disapproval, though, is discretionary. The statute says that the secretary may disapprove a compact. The secretary also may do nothing at all. And in that case, the compact will be deemed approved after 45 days. So for any approved or deemed approved compact, that compact will become effective when the notice of its approval or deemed approval is published in the Federal Register. But additionally, sometimes the secretary may issue an explanation for its decision, whether it's approval, disapproval, or deemed approval. And those explanations have been helpful to tribes and states in figuring out what will the secretary approve and what won't it approve. And we'll talk more about those explanations as informing the proposed regulations.
So it's fair to say that, as is often the case for complex federal statutes, there are gray areas that are left, and those gray areas can be filled in various ways. And so this idea then that we might either have some greater explanation for the secretary's action, or we might lack that explanation. We might have some precedential value or guidance for the future or not. Maybe that tells us something about eventually the need for these proposed rules. Is that fair to say? Okay. So keeping that in mind, Steve, we can go to the next slide.
So we've talked about this careful construction that Congress did in IGRA with creating the compact requirement, obligating the state to negotiate in good faith, creating a cause of action where the tribe could challenge whether or not the state had negotiated in good faith. That all comes undone with the Supreme Court's 1996 decision in Seminole Tribe v. Florida. So let's go ahead and go to the next slide and just take a quick review of what that case held. Essentially, what the court held was that state sovereign immunity, as recognized by the 11th Amendment to the U.S. Constitution, prevents Congress from forcing states to submit to a federal court jurisdiction. So that state sovereign immunity does not allow Congress to authorize a lawsuit against a state, like it tried to do in the Indian Gaming Regulatory Act. Now, the Seminole Tribe decision was an important constitutional law decision. Congress, back in 1988, certainly thought that it had the authority to require states to submit to these lawsuits. But the Seminole Tribe case said, nope, this interpretation of the 11th Amendment invalidates IGRA's enforcement mechanism. So the only way that IGRA's enforcement mechanism can operate the way that Congress intended is if a state willingly submits to suit. But in most cases, as we might imagine, states will assert their sovereign immunity. And then the federal court has no option but to dismiss the case under the Supreme Court's decision in Seminole Tribe. So essentially, in a very significant way, the Supreme Court's decision dismantled that carefully constructed compromise in IGRA. Congress was trying to make sure that tribes didn't have the upper hand after Cabazon. But after the Seminole Tribe decision, now states seem to have the upper hand. Let's go ahead and go to the next slide. The aftermath of the court's decision in Seminole Tribe seemed to bear out that idea that states now had the advantage in compact negotiations. For a period of time right after the Supreme Court's decision, compact negotiations just kind of ground to a halt. States were able to use sovereign immunity as leverage. So Congress intended that tribes could say during negotiations, hey, state, we don't think you're negotiating in good faith, and we might go to the federal court to challenge that. But now all the state had to do was say, and we'll assert our sovereign immunity, and you'll be back to square one. So it gave states leverage in those compact negotiations. Most states held to their sovereign immunity with one very important exception. California waived its sovereign immunity and has willingly submitted to these federal lawsuits to allow tribes to challenge whether or not California is negotiating in good faith. That's why we do have some good case law coming out of California and the Ninth Circuit. But the rest of the country, we don't have a lot of case law to tell us about what are the parameters of the state's good faith duty. When is it negotiating in good faith and when is it not? Because we simply aren't getting those cases. States are just asserting their sovereign immunity and that's it. So in those states where the state is asserting its sovereign immunity, the compact negotiations are very, very different. We can see that by an increase in revenue sharing demands by states, not only in the number of states that are asking to negotiate revenue sharing as part of the compacts, but also the amount, whether it's a percentage amount or a dollar amount that the states are asking from the tribes in revenue sharing. More on that in just a moment. States also are asking tribes to include more tangential topics in the compact, things that are not, at least arguably, directly related to gaming. So states might ask tribes to enforce state child support orders or to garnish casino employee wages in order to fulfill state court orders, things like that, or to submit to state environmental regulations. So we're seeing more tangential negotiation topics come up. And as Steve explained too, the compact negotiation dispute, when we're in a state that has asserted or will assert state sovereign immunity, when the tribe and the state reach an impasse in compact negotiations, it's mostly just resolved through the continuation of negotiation, often with state political pressure. So we see that play out, for example, in a state like Oklahoma, where tribes and the governor are talking to the press, talking about what they see as the impasse, what would be fair, and so forth. So we see things playing out in the political arena more than Congress would have anticipated in IGRA, where we would have thought this would have been settled by a federal suit.
So again, as we're rolling toward really understanding the impetus for these proposed rules and some of the gaps or gray areas that they may fill in as rules tend to do, keeping in mind these different kinds of negotiation topics and tactics, the idea of states increasingly going public, if you will. So in the court of public opinion as well, litigating negotiation over compacts or expansion of gaming or other areas. Thinking about the nature of the political process within a state, the interactions or the arguments or the ideology between or among a governor and the state legislature becoming increasingly significant. And that key question of where the tribe and tribal government, the primary beneficiary of this gaming, where the tribe sits in relation to this and how much leverage the tribe has. So these are all areas that we'll keep in mind as we think about these proposed rules. We'll go on to the next slide as we're telling the story here.
So everything that we described in the aftermath was seen by tribes and by the Interior Secretary as problematic, as not fulfilling Congress's intent under the Indian Gaming Regulatory Act. So one of the things that the Interior Secretary did was to promulgate federal regulations that would be a fix, an administrative fix for the Supreme Court's decision in the Seminole Tribe case. So through these regulations, what the Interior Secretary attempted to do was to give an avenue for a tribe that thought that the state was not negotiating in good faith, but couldn't bring a federal lawsuit because the state asserted sovereign immunity, to allow a tribe an administrative path in that circumstance. So if a tribe thought that the state was not negotiating in good faith, what the tribe would do is try to bring that lawsuit under IGRA. And if the state asserted sovereign immunity, in which case the federal court has no option but to dismiss the case, then that would trigger the applicability of these federal regulations. And it would allow the secretary then to oversee a sort of administrative process that was meant to replicate what would have happened in federal court, starting with a determination of whether or not the state had actually negotiated in good faith. And if the state hadn't, allowing then under the regulations, the secretary to try to encourage the state and tribe to reach a compact. Failing that, to appoint a mediator to allow the mediator to help them reach a compact, and failing that, again, the last ditch step of having the secretary issue administrative procedures or that administrative compact to allow the tribe to operate Class 3 gaming. But two federal circuits, the Fifth Circuit and the 10th Circuit, have struck down these federal regulations as exceeding the Interior Secretary's authority under IGRA. Those circuit courts have reasoned that Congress allowed the federal court to determine whether or not the state had negotiated in good faith. These administrative regulations, at least according to our two federal circuits, allow the secretary to determine whether the state has negotiated in good faith. And that, according to those two federal circuit courts, is an overstepping of the secretary's authority. So as a result, the secretary has been reluctant to aggressively follow through on these regulations for fear of having the regulations invalidated even more broadly beyond the Fifth Circuit and the 10th Circuit. So although we have an administrative fix on the books, it hasn't been terribly effective. And in two circuits, it has been completely invalidated. So we still have a lot of issues about how states and tribes can fairly negotiate compacts.
And so we'll go to the next slide.
So what we'd like to do now is set out 4 of those issues and talk a little bit about each of those issues. And as we'll find out, each of these issues is addressed in the proposed federal regulations. So we thought what we'd do is set out our 4 issues and then turn it over to John for a chance to talk in more detail and depth about the actual regulations. And we can come back to each of these issues and the proposed regulations. But we thought it made sense to focus on these because these are recurring issues that have come up or will continue to come up and are big enough that they can cause problems in tribal state negotiations.
And of course, they also feed directly into the rationale for the proposed rules.
Absolutely.
So the first one that we'll touch on is revenue sharing, and we can go to the next slide. So if we come back to IGRA's statutory framework, and again, some folks may be familiar with this, but it's worth laying out the idea that on the basis of tribes' sovereignty, tribal sovereignty, IGRA expressly prohibits a state during the negotiation process or in compacting itself from imposing anything that looks like or actually would be a tax or a fee on the tribe, other than for defraying some specific costs, regulatory costs. IGRA says that states cannot impose any tax, fee, or charge or other assessment on an Indian tribe or any other person or entity authorized by an Indian tribe to engage in a Class 3 activity. So our first understanding then is no tax on the tribe, no fee on the tribe, no assessment on the tribe on the basis of tribal sovereignty, no leverage for a state to attempt to assess a tax or fee on the tribe in return for the right to open a casino or to offer specific games. So we'll hold that in mind. Go on to the next slide. Just looking at Catherine for any additional comments. So in terms of the so what part of that, in thinking about IGRA's requirements, if there's a way to construe what the state is doing as attempting to levy a tax or a fee or other kind of assessment, that is a presumptively bad faith in terms of negotiations. So as IGRA spells out there, as you can see in terms of the statute, in determining whether a state has negotiated in good faith, a court that would be reviewing this shall consider any demand by the state for direct taxation of the tribe or on any Indian lands as evidence as that the state has not negotiated in good faith. So we have that expressly laid out in IGRA.
So we can go to the next slide. So how is it then if IGRA prohibits states from taxing Class 3 tribal gaming, and if a state tries to tax Class 3 gaming, that would be evidence that the state is not negotiating in good faith? How is it that we have compacts with revenue sharing provisions? Well, that comes from about 2.5 decades of the Secretary reviewing compacts that include the tribe agreeing to make payments to the state under certain circumstances. So what the Secretary has done is distinguish between an impermissible tax and permissible revenue sharing. So permissible revenue sharing is distinct from a tax because it is, according to the Secretary, a voluntary payment, not an imposed tax, but a voluntary payment made by the tribe to the state in return for something that the state will give the tribe. So it's negotiated. The state must give the tribe something that is a valuable economic benefit. So not just the right to operate Class 3 gaming, but something above and beyond that will be a valuable economic benefit to the tribe. So that sounds great in theory, but what is the legal standard for figuring out the difference between an impermissible tax and permissible revenue sharing? So remember, outside of California, when a tribe thinks that a state's revenue sharing demands actually amount to a tax, the tribe doesn't have a way to challenge that in federal court if the state asserts sovereign immunity. That's our Seminole tribe decision. So we don't have case law telling us what is the difference. We have a few very important cases coming out of California, which are very helpful, but we don't have a lot. We don't have a lot of law. So the only other check that we have on those state revenue sharing demands are the Secretary's review of a negotiated compact that includes a revenue sharing provision. But remember, that comes only after the tribe has agreed to that provision, and presumably both the tribe and the state want the compact to be approved. So this isn't the tribe's challenge during negotiations. This is the Secretary's review after the tribe and the state have settled on the terms of the compact. So we do have those explanations that the Secretary sometimes issues when it approves or disapproves or allows a compact to be deemed approved, explaining here is the issue with this revenue sharing provision, or this is why this revenue sharing provision is okay. But again, we don't have a lot of case law, and we only have those explanations in terms of revenue sharing.
So again, we see a gap or potential gaps. It's important for us to recall also that as we're talking about the Interior Secretary generically, of course, this is taking place over time. We're getting guidance that may come from an Interior Secretary under one presidential administration that may or may not be applicable or followed the same way under another administration. It doesn't have to be, and so we have a gap there that may need to be filled. So again, we're moving toward the rules. Let's go on to the next slide.
So over the last 2.5 decades or so, the Interior Secretary has had the chance to review compacts with revenue sharing provisions and to develop a standard. Again, thinking about the Secretary will take into account those few cases out of the Ninth Circuit, and the Secretary will also take into account what it has previously approved or disapproved. But as Steve noted, that might vary with presidential administrations, and it might vary with political climate.
Mm-hmm.
But essentially, we can piece together a legal standard that the Secretary has stated that it will apply great scrutiny to revenue sharing provisions, but it will approve them if they are voluntary and they appear to be negotiated. So the state has to give something to the tribe. It has to give the tribe that valuable economic benefit. And for a number of years, the Secretary was looking for a substantial exclusivity, right? That would be an example of a valuable economic benefit, where the state says, guess what, tribe? Not only are we going to enter into this Class 3 compact with you, but we will agree not to legalize commercial gaming, commercial Class 3 gaming in our state if you are willing to give us revenue sharing payments. So that exclusivity could be a valuable economic benefit to the tribe.
A very well-timed comment in response to a very well-timed question that we believe just came in on the chat as well. So a great example of a valuable economic benefit would be that idea of exclusivity in that particular state or in that jurisdiction or for a particular kind of game.
But the Secretary also pays attention to how much is the tribe paying for that benefit. So the tribe, the deal has to be fair. The tribe should not be paying the state more than the benefit is worth. So it has to be appropriate, right? It has to be justified. The payments have to be justified by the economic benefit to the tribe. If the tribe is paying too much, that would be an impermissible tax. So we can come back to this with John's guidance and help, but importantly, the proposed federal regulations incorporate and expand on this standard of review that the Secretary will use in looking at a compact with a revenue sharing provision. So instead of trying to piece together, here's a couple of Ninth Circuit cases, and here are some past explanations from the secretary, we would have federal regulations that lay out that standard.
So let's hold that idea in mind.
And move on to our next issue.
Our next issue in thinking about compact provisions and the question of what is directly related to the tribe's gaming operation. We'll go to the next slide. So IGRA specifies for us categorically a number of permissible compact provisions. Generally speaking, they fall into these kinds of areas or buckets. Issues related to licensing and regulation, general regulation, the allocation of jurisdiction over the gaming operation, the any potential assessment on the tribe, not as a tax or fee that's impermissible, but assessment to defray various regulatory costs at the state or local level. How the tribe may impose taxes itself.
Which it rarely does.
Which it rarely does, but categorically that's there. Any breach of contract and the remedies there too. And really importantly, sort of the minimum control standards, the various operating standards for the casino operation and the games within that facility. Now, for our purposes, though, it's the addition on the right side of the slide that's significant and also opens the door, there's space to think about what this means. But IGRA does specify that other permissible compact provisions include any other subjects that are directly related to the operation of gaming activities. And so we can imagine or construe or think about what those areas might be. But again, with our theme today of filling in gaps or filling in gray areas, we need to think about what does it mean to say directly related to the operation of gaming activities.
So next slide. So we have seen in compact negotiations and also in previously approved compacts, which is important to note, that states have made demands for provisions that arguably are outside of that catch-all of other topics directly related to the operation of gaming activities. So one example is that states have used the opportunity of compact negotiations to try to settle other issues that they might have with the tribe. For example, we might see the state trying to include in compact negotiations the settlement of whether or not the tribe is going to tax tobacco sales on its reservation in accordance with state law. Or we might see the state trying to resolve issues with tribal treaty hunting and fishing rights. So we've seen states try to include those topics, not just in the negotiations, but in the compacts themselves. We also see states looking to use the tribal state compacts as a vehicle to require the tribe to enforce or apply state law in certain circumstances. So for example, we might see the state during negotiations telling the tribe, we want any hotel that you build adjacent to the casino to comply with state environmental regulations or state and local building requirements. Or we want you to garnish the wages of your casino employees who owe child support under state law. Or we want state residents to be able to bring any tort claims that arise out of your casino in state court. If they slip and fall in your hotel that's adjacent to the casino, we want them to be able to bring a state tort claim. And we also see states attempting to limit tribal non-class 3 gaming as well. So for example, bringing up Oklahoma again, the current Oklahoma compacts actually refer to and have a restriction on the tribe's Class 2 gaming. So we see states trying to negotiate, if we give you this many slot machines, for example, then we don't want you to be able to operate an unlimited number of Class 2 machines. So we see states trying to put those limitations into compacts as well. So we can go to the next slide. So in these negotiated compacts, right, if we're in California, the tribes can challenge those demands in federal court under IGRA's enforcement mechanism and say that the state is not negotiating in good faith. But in most other states, those issues are going to get hammered out one way or the other through negotiations and come to the secretary for review. So one of the things that the secretary will look at is whether or not the compact complies with IGRA. And we know that IGRA sets out there are only these kinds of permissible compact provisions of the kinds of topics that can be included in a compact. But we don't have a clear standard in the statute about what is or is not directly related. And we know that there are previously approved compacts that include some of the provisions that with hindsight, we might wonder, are those actually directly related? Again, we don't have much case law thanks to the Supreme Court's decision in Seminole Tribe, but we do have a few cases out of the Ninth Circuit, and the most significant one is relatively recent, a 2022 case where the Ninth Circuit set out not only what would be directly related to gaming, but when the state could overcome a tenuous relationship with gaming by offering the tribe a benefit. Could we negotiate, could we allow the state and the tribe to negotiate provisions that weren't directly related? The Ninth Circuit said no. So our proposed federal regulations create a standard for what is and what is not directly related to gaming, and therefore what can and cannot be included in the compact, along with some very specific examples. And again, maybe we can come back to that one with John's guidance and help. But for now, we'll just focus on the issue and know that the proposed regulations are meant to address that.
So we've talked about revenue sharing and some gaps or unknowns there. We've talked about what's directly related to gaming and some gaps or unknowns there. Steve will go to the next slide. Our third question is about the scope of gaming and what does such gaming mean? What's permitted within the state? We'll go to the next slide.
So as Steve mentioned earlier, Class 3 gaming is permitted if the state where the tribe's tribal lands are located actually permits such gaming.
Mm-hmm.
So if we're in a state like Utah that does not permit any form of Class 3 gaming, any gaming at all,
right,
we might have a tribe, we might have tribal lands, but that tribe will not be allowed to operate Class 3 gaming under IGRA because it's not located in a state that permits such gaming. Now for Class 3 games, though, this became less of a threshold question and became tied to what was the state obliged to negotiate in the compact. So many courts, federal and state courts, have tied this permits such gaming or this scope of gaming issue to the compact negotiations. So we have a difference of opinion among the federal courts, and we also have a difference of opinion among the state courts that have looked at this issue as well. So in the federal courts, we have a few federal courts that have interpreted the scope of gaming issue as an expansive one, that when Congress referred to permit such gaming, it meant the category of Class 3 gaming. So that if a state had legalized one form of Class 3 gaming, then we would expect that the state and tribe could negotiate over all forms, the entire category of Class 3 gaming. Other federal courts, though, had adopted a restrictive interpretation and said that a state in the compact negotiations only has to negotiate the specific Class 3 games that the state has actually legalized for non-tribal gaming. So the state does not have to negotiate the things that it hasn't actually legalized, and that would not violate the state's good faith duty. And some state courts have taken that even a step further, and they have said that under state constitutional law, the state cannot agree in a compact to games that aren't already legal under state law. So we have this real confusion of court decisions, including the very real possibility, because it has happened, that a tribe in a state would negotiate a compact that would include some Class 3 games that other gaming operators cannot offer in the state. The exclusivity, for example, that is required for revenue sharing. And then it would go to the secretary, be approved, be published in the Federal Register, and get challenged in state court under state constitutional law. And the state court would say, no, the state isn't authorized under our state constitution to agree to these additional games. So this has created a lot of issues about whether or not there is state authority, and also the extent of the state's obligation to negotiate in good faith. So one of the things that our pending federal regulations do is clearly adopt the expansive approach. So the federal regulations indicate that in any state where at least one form of Class 3 gaming is legal, under IGRA, the state would be obligated to negotiate, not necessarily agree to, but to negotiate over all Class 3 games. So that's another clarification that we have in the pending regulations.
Yeah, so a couple of takeaways here from the story that Catherine's telling so convincingly. It includes that last point about sometimes it's construed as that a state has to offer or allow a particular form of game. What we're really thinking about is the idea of what the state is obligated to negotiate with the tribe over, and therefore what a tribe can bring to the table and expect some form of good faith negotiations over. Secondly, the story that Catherine told of an actual example of a state court decision that may be at odds with the approved compact, we have the very real example of Florida and Seminole Tribe. Again, we may have varying degrees of knowledge out there in the audience, but most of us are aware of protracted negotiation and then litigation over the issue of the expansion of sports wagering, and specifically mobile sports wagering in Florida. So this question then of will these proposed rules tell us something about that kind of thing going forward is an important one.
In fact, let's go to the next slide and go to that specific issue.
Yeah.
So this is an example of not necessarily a recurring issue, but an issue that's so important that we would expect it to recur in the future. Can a state and a tribe agree to allow the tribe to operate mobile wagering statewide in the compact? So let's go to the next slide and take a closer look at that issue. So Steve referenced the current compact between the Seminole Tribe and the state of Florida. In that compact, the tribe is authorized to offer statewide mobile sports wagering. And the way that the compact addresses that is it allows the person placing the bet to be anywhere in Florida, and that the person can place the bet on their mobile phone, and the bet will be deemed to occur when it is accepted at the tribe's servers on Indian lands, so that the bet actually occurs on Indian lands and thus can be addressed through the compact and would be subject to IGRA.
So a callback all the way to that Indian lands definition in IGRA and that threshold requirement.
So folks who have followed this issue know that, first of all, this was subject to a federal court challenge. The idea that the secretary should have disapproved the compact because it included gaming outside of IGRA's scope. That is, that people were placing bets outside of Indian lands. So that was the federal challenge, which the district court thought was persuasive, but the appellate court did not. But now it's also subject in many ways to state court challenges. Could the governor representing the state agree to that and still be in compliance with Florida constitutional law, state constitutional law? So we still have some state law issues. But the Secretary of the Interior is well aware that tribes across the country are following that litigation, and that what happens in Florida may lead to what will happen in Oklahoma, or what will happen in California, or what other states might do. So the proposed regulations attempt to get out ahead of this issue by allowing compacts, by expressly allowing compacts to permit statewide mobile wagering as operated by the tribe. And once again, if we want to come back to that in more detail with John's help and guidance, we can. But those are the 4 issues that we wanted to highlight in terms of the proposed federal regulations.
Ooh, there's a lot there, but we think we've teed it up pretty well, and also with for questions and ideas from the audience as well. John, we're happy to turn it over to you at this point.
Thank you, guys. Let you catch your breath here. You covered a lot of territory for us, so thank you very much. Putting it also in a very easily graspable format. I don't know if graspable is a word. So let's move now to the question and answer session. I want to make sure that our viewers have understand that they can present questions. Please present them through the chat, and I will pick them up and present them to our panelists. And then so I'll give it a minute or two here to see if folks want to do that. We had one good question earlier, as you noted, Steve. And here we go.
And of course, John, as well, at any point, wearing your moderator hat, that's great. If you want to step out and offer some thoughts from your expertise and your perspective and your wide experience on what you think some of the implications would be, we're happy to engage in conversation that way too. So whatever works for you is fine. Sure.
Well, so while we're waiting for some more questions to come in, let me ask maybe a very broad-reaching question, but as you noted in the third topic that you covered, this has been around essentially since the IGRA was enacted, and that's this question of the scope of gaming. What do the tribes get to ask for, and what do the states have to negotiate? And I think, as you noted, there's sort of 2 very broad goalposts here. One set out early on by the Second Circuit, which took this position that IGRA speaks very broadly, so it's sort of all or nothing. If a state offers Class 3 gaming, then the tribe gets to negotiate for all types of Class 3 gaming. Obviously, something that the tribes have always been a fan of. At the other end of the spectrum, something a lot more restrictive, and I think one of the early expressed concepts was in the Ninth Circuit by the Rumsey Court, and it laid out that really states can't be forced to negotiate something that's illegal for them, and so the only permissible topics are what are legal within a state. I find it interesting that it is now for a number of years, and I'm not aware that they changed their position, but the position of the U.S. Department of Justice that Rumsey decision really sort of reflected the state of the law. So I guess here's my question. I guess in one part, since we're academics, we can ask these questions. What do you take from this that Interior is looking to expand a definition beyond what the federal government has really stood pat on for several decades now?
So you did a great job of summarizing the Rumsey decision, and we certainly agree with you that the restrictive approach appeared to be the dominant approach, even though a number of commentators had criticized it and had said that the court was kind of confusing this threshold issue with compact negotiations, which should be two separate things. So the proposed regulation, the proposed regulations in the style of these kinds of federal regulations pose a question and then give an answer. So here, the question that the proposed regulations pose is, may a compact permit a tribe to engage in any form of Class 3 gaming activity? And the answer in the regulations is yes. And then the regulation goes on to adopt the approach that harkens back to the Cabazon decision. So as Steve,
May I interject for just a sec? So Steve, if you're out there, can you flash slide 33 up when you have a chance while Catherine's talking? It may help to have that illustration for us. Sorry to interrupt you, Catherine, but I know sometimes.
So we'll just skip ahead here a little bit.
Yeah, for our visual learners as well, we actually have a few slides that may help in thinking about this. Or questions as they come in.
Perfect.
Perfect. Yeah. So go ahead.
Okay,
go ahead.
So the first thing that the proposed regulation makes clear is that it is adopting that approach of the Cabazon Court. So all the way back in Cabazon, before there was IGRA, the Supreme Court said that California was, even though it had legalized charitable bingo and legalized some player banked card rooms, that it broadly permitted that gaming, even though it regulated it very strictly. So the proposed regulation says that if the state allows any form of Class 3 gaming, then the state is regulating all forms of Class 3 gaming. And what that means is that by allowing even just one form of Class 3 gaming, that the state is putting forth a public policy approach that Class 3 gaming in some forms is okay. And that the forms that are illegal under state law, that's a form of regulation rather than a blanket prohibition like we see in Utah. Then the proposed regulation even goes a step further and says that a state's refusal to negotiate in a compact over all forms of Class 3 gaming, assuming that the state has legalized at least one, is considered evidence of a violation of IGRA. So here, I think what the proposed regulations are trying to do is to strike a more appropriate note in thinking about the whether or not a state permits such gaming as a threshold categorical issue, and then separately thinking about everything should be on the negotiation table But there are some forms of class 3 gaming that a state might not want to agree to, and it might have very good public policy reasons for not doing so, but that should be in the framework of good faith negotiations. It should be everything's on the table. Now let's engage in those government to government negotiations.
Great.
So as you noted earlier, I think, Catherine, that it's not that the state has to agree to it, but the state has to negotiate in good faith.
Yes.
Right.
And I think too, Steve made reference earlier to the idea that Congress, through the compact requirement, was trying to promote cooperative policymaking between states and tribes. So if we just apply state law, then that isn't cooperative policymaking. If we think about two governments coming to the table to negotiate something, then we'd expect that that there would be some give and take, and it wouldn't just be the blanket application of state regulation and state law.
Right. So it's that rebalancing idea in practice. It's giving some teeth back to IGRA. But really importantly, as Catherine was saying, it's emphasizing the fact of tribal sovereignty, the fact of state sovereignty, and the idea of the government to government negotiations as a foundation for compacting. So we can't underscore enough, as you did, John, and as we are saying, this is about the idea of being at the negotiating table, and that nothing is off the table just as a starting point.
So I find this a very fascinating discussion in general. But if we look at it from the state's perspective, though, it can put them in a bit of a pinch, right? And I guess here would be my follow-up question: is if a state has 11th Amendment immunity, and then you waive it. So let's use California as a not entirely unique, but one of the, at least I think the first state that agreed to voluntarily waive its 11th Amendment immunity. But it waived it in a particular way, right? Because it waived it by agreeing to a certain set of games. So can the state be forced by the Department of Interior, basically by the federal government, to violate its own constitution, its own laws, as amended by its own? I mean, actually, wasn't the waiver didn't happen by the state government. Remember, it happened by the citizenry of the state who voted for it. But they voted for a particular thing. I'm kind of curious. Federal courts come out all over the place, as we know, right, on these divisions of power between federal and state governments. And in this case, if you cast it in that light, I mean, it looks very much like a conflict between federal power and state power. We have had a tilt for a number of years now in favor, really, of recognizing state authority by federal courts. Not always in the tribal context, but as a general rule, they've been much more receptive to that than they were a number of years ago. So I think it puts this whole question and dynamic in an interesting place.
You're exactly right,
Yeah.
John, that even if we think that this proposed federal regulation is a welcome clarification, it will not resolve the issue of state court interpretation of state law and state constitutional law. So we might still have the situation that we have had more than once in Florida and in other states, where we have a compact that the tribe and the state agree to, that the secretary approves, that is published in the Federal Register, and then is subjected to a state law challenge, and the state Supreme Court says that the compact is invalid under state law. And so that continues to be an issue that this federal regulation will not solve for entirely.
So it looks to me too, one of the things that they hope to accomplish, it's they meaning the department, the federal government, I thought it was interesting that they also categorize, this as, despite the fact that we have some federal court interpretation, that they expressly state that the secretary has authority to issue her own interpretation that may differ from federal courts, and that should be considered, valid federal law. Her interpretation would be considered valid federal law. I think that's an interesting push forward. And adding to that, as you noted, Stephen, I think they are consciously trying to reinforce some of the mechanisms that got lost out of that seminal decision by making this refusal to negotiate a broad set of topics a violation of IGRA, and almost, I think they were probably not wanting to go that far, but almost like a per se bad faith negotiation.
Absolutely. Yeah, can't argue with anything you're saying. Absolutely right.
So let me double check here. Again, I certainly encourage, here we go. We have a question. To what extent does the Wire Act apply to transmissions of sports wagers across state and tribal lines, but within the state's geographic boundaries?
Mm-hmm.
What a great question. Steve, perhaps we could move forward to slide 35 and just bring up the proposed regulation about statewide mobile wagering, because I think we'll need to take our answer implicitly from this.
Right. So it's a great question.
Yes.
It's an important question. And maybe we can help to put it in the context of what the proposed rules are suggesting as well.
So there are two possible issues here. The first one is a possible Wire Act issue when we're talking about tribal operation of statewide mobile wagering. And that's because under some federal laws, when you cross a reservation border, that's the equivalent of crossing a state line. So if you commit a crime, for example, or a certain kind of crime, and you cross, you're within a single state, but you cross in and out of a federally recognized reservation, that can trigger federal jurisdiction because it's treated as an interstate boundary. Mm-hmm. So one of the questions has been, under the Wire Act, if we have a communication, a sports wagering communication that crosses a reservation boundary, will that be in violation of the Wire Act? So implicitly, I think that our proposed regulation says no. And here's why I say implicitly.
Implicit.
So the question and answer of this proposed regulation says, can the compact include a provision that addresses statewide mobile wagering? And the answer provided by the proposed regulation is yes. Now, it anticipates that there would be specific provisions and that the state and the tribe would agree to the idea that the bet would be deemed to occur when it is accepted at the tribe's servers on tribal lands. But still, we know that the mobile phone communication from outside the reservation would cross that reservation boundary. So we also know that in reviewing a negotiated compact, the Secretary of the Interior is going to look for possible violations of IGRA, possible violations of other federal law, including the Wire Act, and possible violations of the federal government's trust responsibility to tribes. So that middle one, that the Secretary will be looking for possible violations of other federal law, like the Wire Act, this federal regulation says that the compact can include this kind of provision for tribal operation of statewide mobile wagering. So presumably, implicitly, the Secretary would not find a violation of the Wire Act. However, that leaves a possible interagency gap, because the Secretary of the Interior is not the official charged with enforcement of the Wire Act, but the Department of Justice is charged with that. And we have had other examples in the tribal gaming context where the NIGC has disagreed with the Department of Justice, and the two agencies have reached different conclusions. The most important example of that is past interagency conflict over Class 2 machines, and whether they are actually Class 2 machines, as the NIGC had held, or whether they were slot machines that violated the Johnson Act, which was the DOJ's position.
So that question that some of us practitioners might remember at the time of so-called bingo slots, and as the technology evolved, the question of whether something that looks like a slot machine and plays like a slot machine, but is not a slot machine, it's a bingo game, actually is a slot machine or bingo. And I think, you know, it's a great question, and Catherine's response helps us to think about it. What we can say is that regardless, the proposed regulation helps to provide clearer guidance to a really important question that has come up and will continue to come up again and again with the promulgation of sports wagering, tribal sports wagering, and that intersection with the Indian lands requirement, which is where, you know, the question of where the bet takes place, and where the bet is accepted. And so at the very least, what these rules attempt to do is provide some clarification on that. And also, backing up one step, encourage the negotiation between the tribe and the state through the compacting process.
So just a couple of additional thoughts on that. We do see tribal operation of statewide mobile, and we do know that at least under our current administration, the DOJ has not tried to shut that down as a violation of the Wire Act. So we have that information. The other thing that I wanted to mention with regard to this proposed regulation is that this clarifies something that that had not been clear before. The NIGC previously had taken the position that the gaming that occurs on Indian lands is subject to IGRA, and gaming that occurs outside of Indian lands is subject to state law. And that's a bright line for the NIGC, that IGRA only applies to gaming that is on tribal lands. So one of the approaches that we have seen with the advent of sports wagering is the separation of, here are the retail operations that are on tribal lands, or here are the mobile wagering that is confined to the reservation. That's all under IGRA.
Mm-hmm.
But here's the statewide mobile that is subject to state law and might even be subject to state license, like in Arizona, or in Connecticut, right? So we saw that very bright line. This proposed regulation seems to say that that bright line won't be important in a situation where the state and the tribe have agreed that the bet is deemed to occur on tribal lands when it is accepted by the tribe's servers, that is appropriate for the compact,
Mm-hmm.
and that will be governed by IGRA.
Thank you for that question.
Thank you for that explanation. That's great. So we have another quick question here. Am I correct in reading the proposed regulation in subsection A on remote wagering to leave the determination of where the wager takes place to state law and/or the compact?
Yes,
Mm-hmm.
it does appear to us as well that the state's got to agree to this in one way or another, either because state law is clear on the topic, or because the compact is clear on the topic. And I think that the reason for that is because we need to continue to be careful of other federal laws, including UIJA, the Unlawful Internet Gaming Enforcement Act. So we need to make sure that under state law, or at least the compact, that the state agrees that the bet is deemed to occur there. Because if it's deemed under state law to occur within the state, then we need to worry about a couple of things. If it's legal, we need to worry about state regulation. But if it's illegal, then we need to worry about a possible federal violation under UIJA as well.
Right.
Next question. Let's see. I know the Supreme Court lifted the stay on the Seminole case last year. Is there a scenario where something like the Seminole case gets heard by the Supreme Court, similar to a number of Indian-related issues brought in the past few years, the ICWA case, McGirt, etc.? So I'm curious if that is something that scholars are concerned about with IGRA. And I would just say, I think there was general concern that there might be a sort of a broader take up of IGRA as the Seminole case was kind of working its way through. But I like your views, but it seemed to me like the federal courts actually didn't want to get into a broad discussion about IGRA itself, but confined themselves to the issues right before them.
Mm-hmm.
Yes, and John, I think we actually had a chance to chat with you about an issue related to this a few months ago, about whether or not IGRA would be vulnerable to the same kind of challenge that ICWA was subjected to. And so one of the things that that might be important to note is that IGRA refers very clearly to tribes rather than to individual Native Americans or individual members or citizens of federally recognized tribes. So that might be one significant difference. But we do see more openness of courts to hear these kinds of equal protection challenges or similar challenges to IGRA that most of us would have thought had been settled long ago. But I think, John, your point about that one possible takeaway from the Supreme Court's treatment of the Florida case is that it's confining the issue to the mobile sports wagering and so forth, rather than the broader legality of IGRA.
Yeah, I think my only addition there would be just sort of underscoring that question about, do scholars or practitioners or others have some concern about the possibility of these relatively settled matters being taken up while there are unsettled matters that are attempting to be settled? I mean, that is still a possibility. Catherine's correct that placing IGRA on the firmer ground of seeing Indian tribe as a political status and a government status as opposed to an individualized status should foreclose the possibility of any question about so-called race or ethnicity or special preferences or those kinds of issues that appeared to have been brought up, I believe, in the footnote. Was it Justice Kavanaugh's footnote? But raising the question of whether race or ethnicity is an issue for a statute like ICWA. And here, if you think about the firmer ground of political status and government status, it should foreclose that possibility. The other thing of note for the ICWA case, and to some degree thinking about ultimate cases that may ultimately come up to the U.S. Supreme Court, for some, is Justice Gorsuch's very vehement and well-informed and passionate defense of tribal sovereignty and the history of indigenous nations and that kind of thing relative to federal Indian law and policy. But that said, none of these questions that appeared to be settled necessarily are settled in the foreseeable future, just look at any area, seemingly big area of the law in recent years? It's a great question.
Great. Let's we got a question here. I think it's going to move us onto one of the other topics, which will combine, I think, both the revenue sharing as well as this question about deemed approved and approved, which the department is trying to provide some clarification as well. Here's the question. However well-intentioned at its inception, the effect of the deemed approved process for Indian tribes has emboldened states to demand compact provisions that do not comply with IGRA. Arguably, deemed approval shifts the burden of proof and expense onto the Indian tribe to prove that the state's demands are unlawful, which empowers the state to insist on unlawful provisions that undermine tribal sovereignty. Isn't it a better policy for the secretary to disapprove every compact that contains provisions that are not directly related to the operation of gaming activities? Which sounds very much like a couple of the comments that were made to this proposed rule. Thank you for the question. You have some thoughts on that, professors?
What a great question. And Steve, maybe we could move back to slide 29, which starts us out with the proposed regulations related to this issue. So one of the things that we mentioned in setting this issue up is that there are compacts out there that have been previously approved that include some of the provisions, some of the kinds of provisions that this federal regulation would say should not be included in a compact. So I think that the question highlights something that the secretary in recent explanations accompanying disapprovals and approvals and deemed approvals. One of the things that the secretary has highlighted is kind of the balance between how rigid should the rules be when the secretary is relatively sure that the tribe actually agrees with these provisions and has, at least on the face of it, sufficient leverage with the state so that the secretary feels like or is of the opinion that these negotiations were government to government, even if the secretary is concerned that that outcome wouldn't be right for every tribe. That's a long way of saying that the secretary has taken to heart the idea of that disapproval is discretionary, and that what might be right for one tribe might not be fair or right for another tribe. That where a state demand with a tribe that has a good relationship with the state, has political clout within the state, is a significant player within that state, that maybe that negotiated agreement is right for that tribe. But in a different circumstance, we might worry about the state applying too much pressure or uneven bargaining power and so on.
In other words, that the playing field feels relatively level, I think is what you're saying in that particular instance. And that idea of administrative discretion being used to make an informed judgment on that basis, rather than applying a bright line kind of standard.
Right. So we saw that come up in the recent explanation accompanying the deemed approved outcome of the new Florida Seminole Compact, right? With specific regard to revenue sharing, that the amount of revenue sharing bothered the secretary, bothered the Department of Interior, but the secretary at the same time was confident that the Seminole tribe had sufficient bargaining power and had sufficient financial wherewithal to make those payments. That not only did the tribe have a particular relationship with the state, but that the financial success of the tribe's gaming enterprises gave it the wherewithal in order to make those payments.
And still left the tribe as the primary beneficiary of the gaming operations, which is a necessary requirement as well.
So that's an example where we can see that discretion playing out in a particular way. But the question asker's point, I think, is a really good one. The proposed regulations, Steve, if you wouldn't mind hopping ahead to slide 31.
One more.
Yeah. So the proposed regulation sets out, hey, here are some provisions that we don't think are directly related to gaming. And so goes through all of these, and we can come back to this in a moment. But again, calling your attention to that final subparagraph D. The inclusion of these kinds of provisions that don't have a direct relationship to the operation of Class 3 gaming are evidence of a violation of IGRA. But remember that the Secretary's disapproval is discretionary. So just because there's evidence of a violation of IGRA does not mean that the Secretary has to disapprove the compact. It could allow it to be deemed approved, or it could actually affirmatively approve it if it was so inclined. And that, I think, is at the heart of the question. Would a bright line rule be better? I don't know that I take a position on that, but I think that it's clear from the draft provisions, the draft regulations, that the Secretary's provision is, excuse me, I'm getting caught up in my words. It's clear from the proposed regulations that the Secretary's position is to hold on to that discretion and to look at the totality of the circumstances, this particular state and this particular tribe, and what is the specific provision at issue before deciding whether or not to approve, deem approve, or disapprove.
And we should say too, John, we certainly invite, if you want to offer your thoughts on any of this as well.
Or tell us where we're wrong.
Or
Absolutely.
but it's such a good question, and it may not have a 100% clear answer. So you might have thoughts as well. So.
Sure. Well, I do, it's something that people have a lot of views on in different positions. And I think the question posed is a great one because a number of folks have said you would most empower the tribes if you think that it violates IGRA, just deny the compact, right? Now, there's a lot of tribes that over time push back on that because, look, they say, we negotiated hard. There's a few things we didn't really care for. Maybe they violate IGRA, but we can live with that, right? So I think clearly the Secretary heard that, and wanted to accord, that sort of position for flexibility that the tribes are putting to her. But I do find it interesting with the deemed approved letters, as you know, there has often been an explanation of the department's discomfort with certain provisions, others in which they have said outright, we think this violates IGRA, but we're going to go ahead and let it go into effect anyways. And but in the comments and the explanations in this proposed rule, particularly around questions like this, I think the department took a great pains to try to say, we try to walk this line. We are not in the business of providing free legal advice to people, because some of the comments said, well, you should just say that violates IGRA and we'll support you in court, right? And so, they obviously, the department did not want to put itself in the middle of that. But then the flip side, as I said, some people question, well, then what are those letters really worth anyways? And particularly, I think one that was particularly troublesome was the Seneca case out of New York, right? In which, the department had clear positions on the length of the compact, the provision of the revenue sharing and when it was supposed to end, and that was all ignored when the arbitration panel reached its conclusion. And so despite what seemed to be a lengthy and pretty clearly explained letter by the department, that was all ignored, and it didn't seem to provide any help or benefit to the tribe. So I'll give you my opinion. I throw it out there. I think that most of these compacts now do provide provisions which say, that if a particular provision in the compact is deemed to violate IGRA, it can be stricken so that the main agreement stays in place, which is really what the department is trying to do with these in these cases anyways. I think that the department's going to go through the exercise of providing a letter and not have it be free, free legal advice or something that it doesn't want to get into. Then it should state that that compact provision in the view of the department, is stricken from the compact and is not enforceable. And if they would, if they're willing to issue this letter, then they need to be willing to add that statement, and that would be sort of this middle ground that might give the tribes a little more leverage in these situations. That's just my view on that, but something that, again, has come up from time to time. And again, the tribes have been all over the place, so that obviously hasn't been helpful for the department to take a really strong stand through time. But sometimes I think the federal agency needs to step out on its own and just say, this is going to be the federal policy, and maybe do that. We have
And the proposed regulations are at least one step closer.
Yeah.
Yes. Let's see. I should check our time. How much time do we have left? Oh, we have another question. Back to our internet wagering. The question is, the UIGEA defines unlawful internet gambling as transmitting a bet or wager where unlawful under any applicable federal or state law in the state or tribal lands in which the bet or wager is initiated, received, or otherwise made. Whew. Doesn't that expansive definition require consideration of tribal law, state law, and the compact, and not just the compact? Do you understand that?
That's another really good question, right? And I think implicitly, if we go back to our last slide, Stephen, if we go back to that one, implicitly the answer appears to be, but again, we're kind of guessing here because it isn't spelled out, that the compact by itself can sufficiently reflect state law and policy to avoid that situation, right? Because the compact is something that the state has entered into and the state is bound by. So if that compact deems that the gambling takes place here and is otherwise legal, then it would appear that that should be clear enough for there not to be a violation of UIGA. But it's untested, right? It's untested. So I think that's a very good point.
Let me ask that, put this to you and ask this. Do you think it covers it? So if I was looking at it, I would say, the state law and the tribal law questions are actually handled by the agreement of the compact, right? State can't agree to, supposedly, the state can't agree to something that's illegal for itself. The tribe has to agree to something that's legal for itself. So for those two actors, the compact suffices. And so really, if you're saying that there needs to be some federal law just to confirm, then that's where the Secretary's review comes in. And you've addressed all three bodies of law, essentially. Do you think?
Yeah, I think that's a very good point.
Yeah, succinctly said and on point. Again, though, the questioner asks a really good question, though. There's room for interpretation.
Yes, courts might not agree with us,
right.
but
We're in uncharted territory here, that's for sure.
Yeah.
So I think that was the last question I have, at least for now. So let me return back to revenue sharing, and I appreciate your views. So you would think that they're relatively minor, but I think there are some pretty big proposals in these rules in the definition sections about meaningful concession, right? And substantial benefit. Can you give us a short rundown how you think that fits into this revenue sharing picture? And again, I think it's one of those areas in which the department is trying to strike a balance by supporting the tribes more than possibly have been in the past, but not to take away needed flexibility in these negotiations. Because we know, as we talked about the political problems in getting compacts done, over time, revenue sharing really in some ways became the grease that got them to an agreement. So I think the department doesn't want to remove that needed flexibility, but does want to strengthen the tribe's hands, or maybe equalize the tribe's hand a little bit. Do you have thoughts on how these fit into that?
That's another great question. So Stephen, maybe we could go to slide 27, which includes a summary. And John, with your help, we'll look at some of these ideas in more detail. But the proposed regulation essentially adopts what has been the Secretary's approach. And we have seen interaction between the Ninth Circuit and the Secretary on the issue of permissible revenue sharing. So the Ninth Circuit has noted what the Secretary has approved or disapproved and its rationales for doing so in those accompanying letters of explanation. And at the same time, the Secretary has acknowledged the Ninth Circuit cases. But again, it's important for us to keep those two circumstances distinct. So the Ninth Circuit has been looking at revenue sharing when a tribe is complaining about the state's demands and saying that the state's demands are evidence of bad faith. The Secretary has been looking at revenue sharing after the tribe and the state have reached an agreement on revenue sharing and submitted the compact. So those are two very different circumstances, but the standards have some overlap. So the proposed regulation keeps the idea that the revenue sharing provisions are subject to great scrutiny. Importantly, it makes clear that the Secretary's presumption is that revenue sharing is prohibited. So we start there, which means that the tribe and the state have to overcome that presumption and show that the revenue sharing is appropriate. So the state has to have offered a specific, meaningful concession that will result in a substantial economic benefit to the tribe and in an amount that will justify the revenue sharing payments that are required by the compact for the tribe to make to the state.
So again, just to underscore, we're seeing a codification through the proposed rules on the assumption that they're approved of standards that already have been developed and applied in many circumstances. So that's one. Yeah.
Additionally, the proposed regulation incorporates the idea that under IGRA, the tribe has to be the primary beneficiary of its own gaming operation. So if the tribe is making payments to the state that make the state a primary beneficiary, then that's not appropriate. That's not what Congress envisioned. So the Secretary will compare what is the economic benefit to the tribe and what is the payment to the state. And if the payment to the state is too much, if it's out of whack, that will be a problem. We saw that come up in a Ninth Circuit case where the economic benefit to the tribe of an increased number of slot machines would have resulted in something like an additional $38 million each year. But that out of that $38 million, the revenue sharing that the state was demanding was essentially $37 million.
Right.
So that made the state the primary beneficiary of that additional gaming.
So again, a codification here of something that is expressed through IGRA and its policy goals. It's firmly in place, but just another safeguard or guardrails for the tribe being the primary beneficiary of gaming. There are, of course, other guardrails that IGRA has, and through review of, for example, management contracts by the NIGC and so forth, where the tribe has to be the primary beneficiary of the gaming.
So if the revenue sharing provisions are not justified, then the regulations make clear that that will be evidence of a violation of IGRA. And this kind of brings us back to the prior question, right? So evidence of a violation of IGRA isn't the same as automatic disapproval. The secretary's disapproval is discretionary. It's not mandated by that evidence. So again, we may be left in a situation where the secretary will allow some revenue sharing, some questionable revenue sharing provisions to stand, depending on the tribe, depending on the state, depending on the circumstances, but strike them down or disapprove the compact in a different situation.
Which in some respects may bring us back to, the same question I have about how much benefit is it to the tribe in a negotiating position. Because to be able to pursue a violation of IGRA, the tribe has to be the one to do that. And if the tribe has already agreed to the revenue sharing, I guess I'm not clear on how much benefit that provides to the tribe, but it is certainly, I think, welcome to a lot of folks to see some more clarity, as you noted at the beginning. And many people, some of our listeners included, may not know, that revenue share has no place in IGRA. This was something that really came about as tribes and states were trying to find some way to get themselves to close the gap on reaching a successful compact, and the department sort of created, if you want to call it a legal fiction, but this payment for value is sort of the original concept. But it has become such a huge part of the negotiative compacts that many people now assume it was just part of IGRA. So I think it was just a long-winded way of me of saying I think it is welcome, as the department has for years struggled with how to deal with this question, for them to now put down what they've learned over the years and what everybody has learned into codifying it and give the sort of rules of the game out a little more clearly. Seems to still be a fair amount of room here for flexibility, and I think that one of the other things that has become standard practice, and that they're sort of codifying in this, is the notion of using marketing studies or economic studies to really prove the benefit, the value that the tribe is getting. And in the past now, for a number of years, if there was any question the tribes perceived of whether or not this revenue provision was going to get approved, they would conduct some economic studies to support that. That obviously means the tribes were in support of the revenue sharing that they had agreed to. So that's another interesting provision, I thought, that they would actually codify that in there.
John, if we might pose a question to you. So one of the things that Steve and I have talked about is that this is a nice example of a proposed federal regulation where the value to the tribe might be during negotiations more than in the review process, that it gives something very specific for the tribe to point to and say, we have concerns about this, and we don't want to agree to this, because if this goes forward, this is something that we would highlight during the review process as a possible violation of IGRA. So let's instead look at a clearer legal standard rather than having to piece together case law and secretary commentary and so forth. Let's have a relatively easily readable and understandable federal regulation to help guide our negotiations. Does that seem like part of what the department was trying to accomplish through these regulations, in your opinion, John?
Yeah, I think you're right. But it, as these things do, it also raises some other questions. So one of the things I noted early on when they started this discussion is, they're looking to move this regulation which was really a procedural regulation. It was really just about filing it, and these are the timelines, et cetera. And they're really going into that and making it a substantive regulation, including, highlighting things that will be an evidence of a violation of IGRA, right? And so, again, a lot of these things were developed over time, and it's great to see them in a place so that people can look at. But when you look at a substantive regulation, then at least as lawyers, right, we start talking about, okay, who's got rights that derive out of this, right? So I guess one of the questions I would have is, what rights do the tribe have to enforce this against the state? Or what rights does the state have to challenge a decision by the department out of their own regulations, right? So it's I have no answers. But I think that's certainly, I hope something that they've considered, and because when you go through the regulatory process, that's always got to be at the back of your mind. Okay, we're going to put this out there, and how are we going to defend it? Who is going to challenge it? Who will benefit from it? How do we defend it against those challenges? How do we prove that we've benefited those we tried to benefit? These are all parts of the regulatory promulgation process, and so I'm certain that they did. It will be interesting to see how it plays out.
Well said.
So we're getting close to the end of our time, and we had one final question, which I'll throw to you guys before we close out. Do you have any predictions on the outcome of the online sports betting case in Florida that is now before the Supreme Court?
What a good question.
So I guess my answer would be, rather than trying to predict what the Supreme Court would do, I would say that I think that the circuit court's decision was the better of the comparing the trial courts and the circuit court's decision. I think the circuit court's decision is more in line with IGRA.
That's a good answer.
I'm going to, from my
That's my opinion. That's my opinion rather than a prediction. But
it's a non-answer answer, but there's substance underlying it.
Well, I think I would agree with you. I suspect that the Florida Supreme Court will look strongly to that circuit decision to find a way to say that their state law is legal and uphold it. So well, great. Thank you, guys. Thank you for a great discussion. Before we close, I also want to make sure I give a big thank you to the San Manuel Band of Mission Indians, whose vision and support have made possible the establishment of the Indian Nation Gaming and Governance Program here at the Boyd School of Law. For those of you that are in the audience, this webinar has been recorded and will be posted on the school's website for you to view later if you would like. Thank you all, and I hope you have a great week.
Thank you, everybody. Thank you.